before we even step into this courtroom, you need to understand, this is not just another routine drug case. This is a story about second chances, and what happens when those chances start slipping away. We're looking at state of Texas versus Priscilla Maya, a woman who was given an opportunity back in 2018 to avoid a conviction through deferred adjudication. That's basically the court saying, stay clean, follow the rules, and we won't formally convict you. But here's where things get complicated. Fast forward a few years, and now she's back in court, not for a new crime, but for violating the conditions that were meant to keep her out of jail. Missing check-ins, falling off track, and most importantly, relapsing. Now here's a twist. The court isn't just deciding punishment today. It's deciding her future. Jail time or rehabilitation. Accountability or redemption. And as you watch this unfold, ask yourself, how many chances should someone get before the system says enough is enough? And when addiction is involved, is punishment really the answer? Let's get into it.
2018 CR. All right, if you all could not talk behind the court reporter, please. Just move it towards the end. Court is calling 2018 CR 10107, State of Texas versus Priscilla Amaya. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Lorraine Eastern for Miss Amaya.
And are you Miss Amaya?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Priscilla Amaya who was placed on deferred adjudication in 2018 CR 10107 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on June 28, 2019 for a period of 3 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 5 in Bexar County, Texas. The defendant Priscilla Amaya did then and there fail to report to the supervision officer as directed for the months of November, December 2021 in violation of condition number 5.
How do you plead to that? True or not true?
True.
This moment right here is crucial. And if you're not familiar with courtroom language, let me break it down. When she pleads true to the violation, she's essentially admitting that she broke the rules of her probation. That's huge. This isn't a trial anymore. There's no debate about whether she violated the terms. The only question left is, what should happen to her now? And notice what the judge just did. He clearly laid out the consequences. Up to 2 years in state jail and a hefty fine. This is the system making sure there's no confusion. She knows exactly what's at stake. But here's the deeper issue. When someone admits fault like this, does it show accountability or does it signal that they've already given up fighting? What would you do in her position? Take responsibility and hope for mercy, or try to contest it?
Waive the remaining violating conditions, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, there is, Your Honor.
Yes.
Yes, for adjudicate guilt, revoke the provision, and sentence the individual to 11 months in the state jail facility.
No objection, Judge. That's our agreement.
All right, Ms. Amaya, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right. So what went wrong with you?
To be honest,
This is where the case shifts from legal to deeply human. She admits it. She relapsed. And not only that, she explains why she stopped reporting. Fear, shame, that feeling of, I've already messed up, so what's the point? And listen closely. She talks about losing connection with her family, her kids being disappointed, and then something changes. She mentions her grandchild. That's often a turning point in cases like this, when someone starts seeing the bigger picture of what's at stake. But here's the reality. Courts hear stories like this all the time. Promises to do better, intentions to change. The question is, how does a judge separate genuine change from temporary regret? Do you believe her here? Or does it sound like something the court has heard 100 times before?
to be honorable, I relapsed and I didn't want to report. I thought working was good enough, but I didn't have my family intact, my kids all together. They were disappointed in me, so they stopped talking to me. But now
I'm sorry, can you speak up?
now I have my kids back in my life and I have my first grandbaby, so I see things different. I know I do need help. And I'm willing to take that help as an outpatient when I get out of Bear County Jail.
Here's the thing. If you want to remain on deferred adjudication, I will let you remain on deferred adjudication. But you're going into inpatient treatment, or either you're going to felony drug court. Now, you say, oh, I want to do my time, I will get out, and I will take care of things, and I will be clean and sober. 9 times out of 10, that's not going to happen. You know why? Because you are looking at 2 years in the state jail facility, and you couldn't do it. And you are a person who should not be around your grandchildren or your children because you don't have control of your addictions. You're using opiates. You need help. So if you want, here are your 2 choices.
Now, this is a powerful moment, and honestly, not something you see in every courtroom. The judge is laying out 2 very clear paths: punishment or rehabilitation. Option 1, drug court or inpatient treatment, structured, supervised, and focused on recovery. Option 2, 18 months in state jail. No treatment guarantee, just time served. And the judge doesn't sugarcoat it. He straight up says, most people who choose jail over treatment don't come out better. That's a harsh truth backed by real-world outcomes. But here's the psychological twist. For some people, jail feels easier. It's predictable. You serve your time and you're done. Treatment? That requires confronting addiction head-on. So what would you choose? The harder path that might actually change your life, or the shorter path that just gets it over with?
Choices. State and defense, they came up with their agreement. Here's your choice. 1, you can be referred to felony drug court. If felony drug court accepts you, great. If they don't, you go into inpatient treatment. Or you can go to the state jail facility for 18 months. Either way, your life, the time is going to pass. Either it's going to pass with you bettering yourself by taking care of your drug addictions, or either it's going to pass with you marking days off the calendar, just doing your time at the state jail facility. So, which do you prefer? 18 months at the state jail facility, or perhaps getting treatment for your drug addiction, being the type of grandmother that your grandchildren can be proud of and that your children can be proud of? It's completely up to you.
Yes. May we have a minute, Your Honor?
Yes. Maya, are you still discussing? We're ready, Your Honor. All right. So we're back on the record. In 2018 CR 10107, State of Texas versus Priscilla Amaya. So, Ms. Amaya, have you had a chance to discuss things with your attorney?
And
So
there
which
it
do you
is,
prefer?
the decision. She chooses jail time. This is one of the most debated choices. In cases like this, on paper, treatment seems like the obvious better option. But in reality, it's not that simple. Treatment programs can be long, demanding, and emotionally exhausting. Some defendants feel they're setting themselves up to fail if they choose that route. Her attorney does try to soften the impact, asking for a therapeutic community recommendation while she's in jail. That's essentially a request for some level of rehabilitation during incarceration. But still, this is a turning point, because by choosing jail, she's stepping away from a structured recovery path that could have kept her out of the system long term. Do you think she made the right call here? Or is this a missed opportunity that might come back to haunt her?
We're going to take the state jail time, but we are requesting that the court, if the court has the ability to refer or recommend her to a therapeutic community there for drug treatment, we are requesting that.
All right. Then the court.
I think that will allow her to get some credit for her time at state jail.
All right. Is she waiving her right to appeal then or no?
Yes, Your Honor.
All right.
The sentence is official: 18 months in state jail with credit for time served. And notice something important. The judge agrees to recommend treatment, but he makes it very clear he doesn't control that placement. That's a key detail a lot of people miss. Judges can suggest programs, but once someone enters the correctional system, decisions about treatment often shift to the facility itself. Also, by waiving her right to appeal, this case is essentially closed. There's no going back, no second-guessing the outcome in a higher court. So now the focus isn't legal anymore, it's personal. What does she do with this time? Does she take advantage of any help offered? Or does this become just another cycle? Because at this point, the system has done its part. The next move is entirely hers.
Then the court will find you guilty. The court will grant the motion, sentence you to 18 months in the state jail facility, give you credit for any time served, and the court will recommend the therapeutic community. Therapeutic community will not increase the amount of time that you're in custody, but I do not have the authority to have them place you in there. The only thing I can do is request and recommend it, but you're also going to have to ask for it. You understand?
Yes, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement,
Well, not
Well,
actually.
she's waived her right to appeal.
Okay, that's right.
Yes.
You're right.
Thank you. And you've waived your right to appeal. You do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
I'm 40.
All right, you're 40. You still have a lot of your life in front of you, and you need to make a decision. And I know staying clean and sober is hard. And this is from somebody who's never done drugs, but I understand it's hard based upon my experience in different treatment courts and based upon the fact that I'm having a struggle giving up ice cream. And ice cream is not even as addicting as the drugs that you're taking. But if you don't stop, one or two things are going to happen. Either you're going to continue going in and out of the prison, or either you may end up with a bad batch and you may end up overdosing. And I don't think you want your children or your grandchildren to read about you in the news where it's bodies found on whatever street it is, and then they finally identify it and it's you. You understand? But you're going to have to work for it. And when you get out, there are plenty of places that have free treatment for you. Okay.
Yes, ma'am.
All right. Good luck to you.
Thank you, ma'am.
You're welcome.
Thank you, Judge.
Thank you.
Please subscribe to help the channel.
This case is a powerful example of how the justice system tries to balance accountability with opportunity. Priscilla Maya was originally given a second chance through deferred adjudication, a chance to avoid a conviction altogether. But after violating those terms, the court had to step in and make a difficult decision. What stands out here is the judge's approach. He didn't just hand down punishment. He offered a real alternative: treatment, recovery, a path forward. But in the end, the defendant chose incarceration, even with the possibility of rehabilitation support inside. And that raises a bigger question. How effective is the system at guiding people toward better choices when addiction is involved? Is it enough to offer help, or should there be stronger intervention? Cases like this aren't just about the law. They're about people, consequences, and the struggle to change. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.